ama unajaribu then I give the answer. What's your view?
Na answer, wacha tuandike Bukumbo orals ndio niandike.
Okay.
But unaweza niacha nijaribu zingine kama nataka.
Oh yes, it's an open field. Sawa. Haya. Okay. When you are ready utaniambia. So we had left at question 78. Question 78. Question 78. What is the mandate of the National Land Commission on historical land injustices in Kenya? That was a question that was asked. I can maybe mute the participants. Okay, thanks. So we have started. What is the mandate of the National Land Commission on historical land injustices? The floor is open for anyone to unmute to try before we read out the answers. We are in question 78 before your screen. Any member to attempt?
I think now because many are going, we will just go question and answer. But if anyone wishes to answer, they can raise their hand so that we don't waste a lot of time asking who's ready, who's not ready.
True. Exactly. So for that, I presume no one is ready to answer. So the question is, what is the mandate of NLC on historical land injustices? And the answer is that the National Land Commission's mandate on historical land injustices is to investigate the claim and make recommendations on appropriate redress. It does not issue binding judicial orders on ownership. So constitutionally, the mandate of NLC is derived from Article 67(2) of the Constitution, where the NLC is mandated to initiate investigation on its own initiative or on a complaint into present or historical land injustices and recommend appropriate redress. Section 15 of the National Land Commissions Act 2012, which is also providing a framework for receiving, investigating, and determining whether a claim qualifies as a historical land injustice and then recommend the appropriate redress. We have seen courts decisions that have also reiterated the same, where we have the Republic versus National Land Commission, a 2024 decision where the NLC acted within mandate. The decision ought to have been recommendational and not a binding judicial order. So other times we have seen the NLC must declining or a court will stop it if NLC still insists to proceed where the claim has been determined by a court or is capable of being addressed through the ordinary court system in Kenya. This was the decision known as the Republic versus NLC, a 2020 decision. So the NLC process is still subject to legality and fair process controls, where we have judicial review and constitutional mechanisms to address any party who has been aggrieved by the recommendation offered by the NLC. If you read question 79 is also tied to NLC, so I will proceed to the same so that we determine conclusively on these questions. Does the NLC have the power to give a definite finding or just to make recommendations? And to which institutions are these recommendations made? So the NLC role in historical land injustices, as we have seen, is to make findings for purposes of an inquiry and then issue recommendations on redress. It does not make a final binding adjudication of title or ownership like a normal courts. So this has also been directly addressed in the case of Republic versus National Land Commission, Ruto, and two others versus County Government of Bomet 2024, where the courts have treated NLC's historical land injustice mandate outcome as recommendatory and not a binding judicial order. So to which institutions will recommendations be made? The institutions are the national government, where we have the relevant cabinet secretary and ministry or state departments. These can include policy actions, settlement, resettlement programs, compensation frameworks, public land administration. Then we have county governments, especially where the defunct local authority or county is the successor implementing entity, where we have compensation, resettlement, local public land issues. Then we have chief land registrar, and lastly we have parliament. We have seen a decision that was also made pursuant to the parliament to make appropriate public actions when it comes to legislation that was passed by the NLC. So what are the implementation strategies if you are aggrieved by the NLC order? So administrative follow-up to the implementer. So this is how NLC tries to force, because it is not binding. So the NLC will try to have mechanisms to have a counter check, so that the people whose the recommendations have been subjected to will have administrative follow-up to the implementer, where we have budget or appropriation routes if money and land allocation is needed. So NLC will do thorough follow-ups to the same. We have judicial review and constitutional litigation, challenging illegality or compelling performance depending on the circumstances and the nature of the public duty. Then lastly, if you read question 80 before you, land issues in the coast, evictions due to adversarial system of the courts in Kenya. Have these issues been addressed by the NLC, where we have absentee landlords, tenancy at will, and houses without land? And the direct answer, and to be conclusive, is where we have yes, many coast lands are problems where we have absentee landlords, squatters, and tenancy at will, or houses without land and eviction threats have been litigated and in appropriate cases channeled to the NLC under its historical land injustices mandate. But NLC does not replace the courts on private title disputes, and eviction control largely sits in the Land Act. If you read the Land Act, section 152E, we have private land notices to be issued. These are tied to 3 months notice. Then we have section 152C, where this is where we have public land notices by the NLC. Then we have section 152G of the Land Act Cap 280, where we have mandatory procedures during eviction. So evictions will still follow the mandatory human procedures. So usually, a landlord or tenant, also known as periodic tenancy or ground rent situations, disputes often remain for ELC or civil processes rather than NLC mandate. So courts have recognized that houses without land or eviction in termination requires proper notice and remedies to be granted. So you can't rush to NLC for such remedies. We also have where the dispute is genuinely framed as historical land injustice, where we have long occupation plus contested historical alienation and classification. Courts may refer parties to NLC and preserve status quo against eviction pending NLC inquiry. So that is a brief overview of how the panel was expecting a candidate to answer that question. That is it when it comes to NLC. Question 81. Who is an intersex person? What rights do they have under Article 45(2) of the Constitution of Kenya on the right to marry? Who is an intersex person? Any person, as we have said, you not have to ask. You just raise your hand or unmute directly, and the floor is yours.
Intersex persons ni watu unapataga walizaliwa wakiwa male, and then with time wanakuja wanabadilika, wanakuwa gender ingine. Sema kama from male maybe to female, ama from female to male.
I would say no. Intersex persons are people born with both male and female reproductive organs. So you can find someone looks like a man, has a penis, but also has a uterus and probably a vagina.
Do they have any rights to marry pursuant to Article 45 of the Constitution? Will those marriages be recognized? What is the effect?
Yes, they do. I remember when looking at the Kenya National Commission on Human Rights, they had an intersex persons bill or something that they were formulating. But I have forgotten even its provisions. But yeah, you see, Article 45 talks about every adult has the right to marry a person of the opposite sex based on the free consent of the parties. Usually, if you look at intersex persons, in as much as they have both reproductive organs, they have one that is a bit more dominant than the other. So yeah, you can have both a penis and a vagina, but it's your vagina and your female reproductive organs that are more functional, or another one can have that their male reproductive organs that are more functional. So yes, they do have the right to marry, and even in that marriage, okay, it's constitutionally allowed. Also, I think one of the things that the bill brought about is, you see, these days, even as you're signing male, female, there's usually I in any national document, any formal documents. They are recognized as a gender. So it's not only F and M anymore. There's also an I for intersex persons. And that's the difference. You see, what Peter was talking about is trans people. So that's the difference. There's a difference between transgender and intersex. Intersex persons are the ones who are born with both reproductive organs. But usually, because one is more dominant than the other, you can find out that the male reproductive organ is a bit more functional. So at the end of the day, you'll just live life as a man, even though you have both reproductive organs. So yes, they're allowed to marry.
So thank you, Jebet, for that.
Jebet,
Yes.
I was asking whether you have experienced the intersex persons, whether you have come to kuja one-on-one.
I've interacted with them in person. One of them was even my colleague when I was interning at KNCHR, and they're very lovely people. So, yeah. Yes, Peter.
Peter, they are duly recognized because we have authorities to support the same. An intersex person is a person born with sex characteristics, as Faith has correctly put through, where we have chromosomes, gonads, hormones, or anatomy that do not fit typically binary notions of a male or female character. Under Article 45(2) of the Constitution, this guarantees a right to marry for every adult, but Kenyan marriage law is still structured around a man and a woman. So an intersex person's ability to marry turns on how their legal sex is recognized or recorded under the current law. So to be brief, right to marry is as per Article 45(2) of the Constitution of Kenya, where it is in verbatim. Every adult has the right to marry a person of the opposite sex based on the free consent of the parties. We have statutory recognition of intersex children. If you read through Section 21 of the Children Act 2022, an intersex child shall have the right to be treated with dignity and to be accorded appropriate medical treatment, special care, education, training, and consideration as a special need category in social protection services. Therefore, if you go further to Kenyan decisions, Kenyan courts have recognized persons as a factual or biological category, but have been slow to create a third legal sex category through judgments. So they have tried to push this mandate to the parliament. For instance, I can read one of the decisions where they had tried to do the same. If you read the case of RM versus Attorney General 2010 decision, so the court found that the petitioner is an intersex person. The law as it stands in Kenya recognizes only male and female categories for purposes of legal recognition, registration, and statutory rights. The court held that the petitioner could have been registered under one of these categories and that the lack of a specific intersex category does not amount to legal non-recognition or discrimination under the Constitution. The court further held that the petitioner failed to provide evidence of efforts to obtain identification documents or to show that he was denied such documents due to his intersex status. However, the court found that the petitioner was subjected to inhuman and degrading treatment through humiliation and invasive body searches in prison. So this is a human rights violation pursuant to an intersex person, and we see the courts trying to protect their rights, but they are silent when it comes to recognizing marriages that are formed by intersex people. So Generally, Article 45(2) is framed as opposite-sex marriage. Without a fully developed third make a legal framework, e.g. the Parliament, marriage registration typically relies on male or female legal classification pursuant to what we have currently. So, to answer that is that if you have not defined or you have not registered your intersex personality to a certain gender, then decide to marry pursuant to your free consent, that marriage before the law should appear as of two opposite sex. So you can't have both at the same time.
So maybe just to add on to that, we can go look at the Intersex Persons Bill. I'm not sure that it has already been passed, but Section 15 of that bill proposed that a marriage involving an intersex person shall be celebrated in line with the Marriage Act, and an intersex person who intends to marry shall, on request by the registrar, provide a medical report issued pursuant to Section 12 of that Intersex Persons Bill and any other supporting documents. So that was the proposal of the bill. Perhaps you can just keep checking whether it has already been passed or not.
Maybe somebody can do a check and to see the position. Maybe the panel was expecting an answer to that, to see whether there is a person who is updated to the current affairs. Like, I'm surprised because I was not aware. So there is an Intersex Persons Bill of 2024. How can I track? There is a Parliament tracker to see its Parliament tracker. So if you look at the Parliament tracker, the National Intersex Persons Bill remains pending and stalled in the National Assembly, where the human rights organizations continue to pressure Parliament to expedite the legislation. Let me go directly to the Parliament tracker portal, where I will search the Intersex Bill directly. So there is a bills tracker on its own. That is where you search Intersex. Currently, it is not updated. It is not, but what we can say, as per today, the bill is not yet passed to a law. So that is a very good input. It is testing on current affairs. Thank you, Jabet. So question 82 before you. A demonstrator is arrested by plainclothes officers after arriving home from the demonstrations and is then forwarded to the DCI. His lawyer claims that multiple rights were violated during the process, including his right to privacy, since he was found at home through tracing of his phone activity by intelligence officers. The AG says that the criminal activity he was involved in, and the state may use means including violation of privacy. What will be your finding in this matter? I also leave the question to the panel to try out, to the candidates to try out, so that we read a conclusive answer to the same. In your answer, you can also give the current affair touching this matter, where there was a declaration of unconstitutionality of a certain act or section of the act. A person can confirm the same, because this is also a current affair that is likely to be asked. Okay, so let me proceed with the answers. The finding is that the AG's position, the state may use means including violation of privacy, is wrong in law. Privacy can only be limited by law and in a manner that meets the Article 24 proportionality test. If the phone tracing or surveillance was done without the required legal authority, typically a court warrant, it is a rights violation and any resulting evidence is vulnerable to exclusion under Article 54. Even though the arrest or investigation itself may still be lawful if based on reasonable suspicion. Because we have seen the Criminal Procedure Code pursuant to Section 29, where arrest without warrant requires reasonable suspicion of a cognizable offense. Then, if police enter or search premises without warrant in limited exigent circumstances, they must notify the authority and purpose for the same, and certain safeguards usually apply. Relevance if he was arrested at home or officers entered to the premises to arrest this person. That is pursuant to Section 57 of the National Police Service Act. Then another key takeaway is that covert monitoring of communications or access or search under NIS special operations require High Court warrant where it involves entry, access or search and monitoring. This is pursuant to Section 42 of the National Intelligence Service Act, Cap 206. Another key takeaway you must note is that arrestee must be presented in court within 24 hours or police must seek extension if custody timing is an issue to the above situation. If you read Section 36A of the Criminal Procedure Code, is the enabling provision for that. What are some judicial interpretations in Kenya? We have police or investigators must investigate within the law. Warrantless intrusion into privacy is unlawful and attracts remedies. This was in the case Asiro versus National Police Service 2022. Illegally obtained material can be excluded if admission will render trial unfair or harm administration of justice. This was seen in the case of Moe versus Chairperson of IEBC 2017 decision. Lastly, we have even where investigations serve public interest, the state must use the correct legal route court process to obtain private data, documents. Shortcuts violating privacy will be struck out. This is seen in Kenya Tea Development Agency Holdings decision versus the DCI 2024 decision. This is where the DCI used a wrong route to obtain private communications. So basically, you also take note of the recent matter arising where we have the Kenya Courts of Appeal struck down sections 22 and 23 of the Computer Misuse and Cybercrimes Act as unconstitutional on March 6, 2026. The three-judge bench ruled that the laws criminalizing the publication of false information and fictitious data were overly broad and vague and violated freedom of expression. But currently we hear that the matter has been appealed, I believe, to the Supreme Court. Because this was in the Court of Appeal stages. So that is a current affair that must be at your fingertips. So if you read Section 22 of that Cybercrime Act, Computer Misuse and Cybercrimes Act, where we have Justice Patrick Kiage and Agri Muchelule and Weldon Korir sitting as the bench, say that Section 22 directly provided for false publications. This section criminalized the intentional publication of false or misleading data. Then Section 23 talks on publication of false information. This section criminalizes the publication of fake news that results in panic, chaos, or discredits reputations. Maybe you can be asked, why were the sections struck down? One reason was that they were too broad. The court called them unguided missiles. They were so wide that they could net innocent people who forward messages without knowing they were false. Then they had what we call a chilling effect. The judges noted that what is false today might be true tomorrow. Criminalizing falsity risks silencing satire, opinion, and journalistic errors. Then lastly, we have alternative laws. The court noted that the National Cohesion and Integration Act and civil defamation laws already handle these issues without needing harsh criminal sanctions. So that is where the court decided to say the same is unconstitutional, because you can be asked for the rationale of the court's decisions. And up to that point, I believe we have answered that question with the utmost courage. Question 83. Question 83. NIS has a statute that allows them to gather intelligence and to identify internal and external threats. AG uses this argument stating that it is allowed under Article 24 of the Constitution of Kenya. Maybe to answer this briefly is that we have discussed this provision. Yes, they have an act, and if you read NIS, this was pursuant to Section 42 of the NIS, where they can access or search under special operations. This we have seen that they require a court's permission, authority to undertake covert operations. This is directly lifted from the act, because if you read Part D, Section 42 of the National Intelligence Service Act D, this shall be specific and accompanied by a warrant from the High Court in the case of Paragraph C. Paragraph C is where the written authorization issued by the Director General may authorize any member of the service to obtain any information, material, record, or document or thing, and for that purpose enter any place or obtain access to anything, search for or remove or return, examine, take extracts, make copies of or record in any manner the information, monitor communication, install or maintain or remove anything, or take all necessary actions within the law to preserve national security. That is where they will require a warrant from the High Court. So the AG's comments are not justified because they have an act that has a limitation, because for you to apply the limitation of rights pursuant to Article 24, you have to include the test that we discussed: reasonable and justifiable in an open and democratic society, apply the proportionality test, and use the least restrictive means to limit a right provided under Article 24. So those are the tests on its own. There was a question on that. What test will you follow if a person tries to limit an Article 24 right? The same ought to be reasonable and justifiable in an open and democratic society. It must be proportional and use the least restrictive means. So Article 24 is being invoked by the AG, but limitations must satisfy Article 24(1) of the Constitution: be necessary, non-discriminatory, exceptional, and not derogate the core context. So that is also an additional emphasis to what we have discussed. So generally we have answered that question. Then let us move to question 84. What are the considerations for review under Order 45 of the Civil Procedure Accord? What are the considerations? This is a basic question, and I believe any member can answer on their feet. What are the basic considerations of for a review under Order 45? Then, still on our feet, you can also attempt what are the tests that are required in Order 42 Rule 6 applications in Civil Procedure Accord. To maybe for context, that is where we have an application seeking stay of execution pending appeal. What are the considerations that you have to meet under Order 42 Rule 6? What is the threshold? Because there are some decisions that directly say that some litigants confuse Order 42 Rule 6 test to Rule 52B of the Court of Appeal Rules applications. So that is also a key area that you must be able to answer. What? I leave the floor to any panel, to any member. Okay, considerations for review under Order 45. Order 45 review is exceptional relief. You only get it if you strictly fit the Rule 1 grounds, where we have new and important matter or evidence, there is error apparent on the face of the record or other sufficient reason, and you move without unreasonable delay, otherwise the court will tell you to appeal. So there are some enabling provisions where we have Order 45, Rule 3 of the Civil Procedure Rules. The court dismisses a review if there is not sufficient ground. If there is somebody who was unmuted, let me mute them. Anyway, unajua my screen is it's not reflecting. Any member who was unmuted and is unmute because my screen is frozen. So we have seen the court dismissing a review where there is not a sufficient ground. So if review is granted on new matter or evidence, the applicant must give strict proof it was not within their knowledge or could not be produced at the time. The other key takeaway pursuant to Order 45, Rule 2, is where the application is generally to the same judge who made the order, subject to the rule's exceptions. Then, ground must be one of the Order 45 grounds. Review is not an appeal in disguise. Then, error apparent must be obvious or self-evident. No elaborate argument required. Then, new and important evidence requires due diligence. If you knew of it or could have produced it, review fails and delay will hurt the party seeking the same. So, what are the tests that you can have at the back of your mind whenever you are exercising this route? So pick the correct ground and plead it precisely. If you want to go with new and important matter or evidence, show that it is material, show that it existed or was discovered after. It was not within knowledge and could not be produced even with due diligence, and attach strict proof explaining non-production. Then if you want to go under the error apparent way, identify the specific error on the face of the record, something that stares at you, e.g., is it a mathematical error, is it a clerical error, is it an obvious misstatement, not a debatable point. If you want to go with any other sufficient reason, courts generally resist using this to reopen merits. You must justify why it is review-worthy and not an appeal by another name. Then, promptness. File within unreasonable delay. Unexplained delay is frequently fatal. We have seen decision known as KPLC versus Ramoya, where a review was declined pursuant to the same being filed without explainable delay. So we have finality, re-litigation. You cannot use review to re-argue issues already determined or to introduce evidence you chose not to tender. That is the decision known as Rai versus Shem. Then the correct forum or judge, it is to be filed before the judge who made the order unless Order 45 Rule 2 exceptions apply. Okay. Higher. Let me see the exceptions to be applicable pursuant to Order 45 Rule 2. The exceptions are that if the judge, so this is a direct interpretation of Order 45 Rule 2, to whom applications for review may be made. 2. If the judge who passed the decree or made the order is no longer attached to the court, the application may be heard by any other judge who is attached to that court at the time the application comes for hearing. So that is one exemption. Exemption number 2 is if the judge who passed the decree or made the order is still attached to the same court but is precluded by absence or other cause for a period of 3 months next after the publication for review is lodged, the application may be heard by such other judge as the Chief Justice may designate. That is an exception. Then maybe an additional information, and it can be helpful when court may grant or reject the application brought under Order 45 Rule 3, Rule 1. So Order 45 Rule 3 says that where it appears to the court that there is no sufficient ground for a review, it shall dismiss the application. Number 2, where the court is of the opinion that the application for review shall be granted, it shall grant the same, provided that no such application shall be granted on the ground of discovery of new matter or evidence which the applicant alleges was not within his knowledge or could not be adduced by him when the decree or order was passed or made without strict proof of such allegation. So that is the enabling clause that provides for the powers of the court to grant or dismiss the application. Then the other question that I also asked you, because it was a confusing element, how do courts interpret Order 42 Rule 6 and what are the thresholds that a person ought to satisfy? So Order 42 Rule 6, stay is granted only if you satisfy the 3 mandatory conditions in Rule 6.2. You have to demonstrate substantial loss, you file without unreasonable delay, and give security for due performance. Otherwise, the stay will be refused. So the statutory threshold is in Order 42 Rule 6. No stay unless the court is satisfied that substantial loss may result, the application is made without unreasonable delay, and the applicant gives security as ordered. So for those who have joined now, this is an application seeking stay of execution pending appeal. All the 3 are mandatory. Delay and failure to prove substantial loss or security kills the application. Substantial loss is the cornerstone and bare allegations are insufficient. When it comes to money decrease, substantial loss is typically shown by a real risk you cannot recover the decretal sum if the appeal succeeds. Once you raise a credible refundability concern, evidential burden may shift to the respondent. So we have a decision known as Alice Sheikh Mohammed versus Lucy Malia Kilunda 2017, where the stay granted on deposit of decretal sum, refundability concern addressed by a security. So where there is a refundability concern, as the court will order security to be deposited. So good. I believe now up to that point we have exhausted both Order 45 and Order 42 of the civil procedure rules. So question 85. Suppose you handled a case and you rendered a judgment. One party has filed an appeal at the Court of Appeal, or the other has made an application for review before you. Can the application before you stand? Are there any exceptions? That is still inclined to Order 45. Suppose you handled a case and you have rendered a judgment as a judge. One party has filed an appeal at the Court of Appeal, while the other has made an application for review before you. Can the application before you stand? Are there any exceptions? This is a technical question. So, yes, the review application can stand, but only if the applicant has not preferred an appeal. If the applicant is the one who has lodged the Court of Appeal or a record to the Court of Appeal, the review before you is incompetent. The main statutory exception is where a different party has appealed. The non-appealing party may still seek review unless the appeal grounds are common. Okay? What are the governing rules? If you read Order 45 Rule 1(1)(a) of the Civil Procedure Rules, review is available where an appeal is allowed but no appeal has been preferred. What are the key exceptions? A party who is not appealing may apply for review, notwithstanding the pendency of an appeal by some other party, except 1, where the ground of appeal is common to the applicant and the appellant, or 2, the applicant, being the respondent, can present that case to the appellate court. Okay, so those are the exceptions that the panel were expecting a candidate to extract out clearly. There are some decisions. Once a party has appealed, they cannot then seek review of the same decision. That is settled. A notice of appeal alone may not equal appeal preferred, but pursuing both remedies concurrently is not allowed. Courts will strike out a review filed after a notice on appeal where it amounts to double tracking. So synthesis and key steps that you have to master. If party A has filed the Court of Appeal and party B, being the non-appellant, files review before you, review may proceed under Order 45 Rule 1-2 unless B's review grounds are common with A's appeal grounds or are issues that B can adequately raise in the appeal as the respondent or cross-appellant. 2. If the reviewing party is the same party that has already preferred the appeal, then the review is incompetent and should be struck out. Case management requires parties to place on record the notice of appeal and record of appeal status in the Court of Appeal. So if you want to seek review and there is an appeal, the court will say that kindly bring those documents that you have taken to the Court of Appeal so that we check whether you fall under the exception. A short schedule showing whether the review grounds overlap with the appeal grounds to trigger the Order 45 Rule 1-2 common ground bar. So that was a very technical route because many students were thinking that it could be a direct res judicata or sub judice matter before you. And we have read the same is not sub judice pursuant to some exceptions. What does Chapter 6 demand of a judge? What does Chapter 6 demand of a judge? This can also fall under professional ethics question. This can also fall under professional ethics question. So Chapter 6 of the Constitution demands that a judge exhibit an impeachable integrity. Yes.
Kidogo tu.
Okay.
Nilikuwa nauliza.
Yes.
Difference ya appeal na review ni gani? Ama in what instances?
Yes.
In what instances can someone appeal and in what instances can one seek for review?
Okay. When it comes to the difference between the two, kwanza tunaanza na the threshold set for you to review. Kuna some criteria and thresholds that the court will consider. Is there any error apparent on the face of the record? Alafu review is majorly also done to before the same judge who passed the order. Alafu pia we have seen clerical errors or there is new discovery of evidence. Na hii evidence, even after due diligence, this party could not have recovered ama hangeipata, unaona, or any other sufficient reason, but any other sufficient reason will be tested isikuwe ni kama the reasons that can form part of an appeal. Remember, review is restricted to rectifying an order as compared to bringing new issues that are to be determined, because the court cannot sit in a review application like as if in a review its own judgment. Hiyo ni sunana itakuwa una go beyond the scope of your powers. You can't sit on your own order as an appellate court. But when it comes to appeal, we have seen that some application, some judgments or some provision that says there is an appealable right, provided where statute imesema this. Kama ukiangalia, if you are to analyze the civil procedure rules, you realize that there are some orders ukibreach ama upate a judgment against them, uta appeal as of right to the high court or to the court of appeal. But we have also seen decisions zenye zinasema that for instance develop hii mambo ya kuappeal, like we saw in the new 2 Agrovet decision when it comes to arbitration act, arbitration proceedings, where iko na exception fulani, because we know that arbitration matters will end at the high court as the final appellate authority. But we have seen a very strict narrow gate to the court of appeal rules, where it says that if the judgment was obtained by illegality, the high court judgment was obtained by illegality, then in that situation you can appeal to the court of appeal. That was a Supreme Court decision that made that ruling. Another angle that you also have to interpret on appeals is where we saw a recent decision, succession court decision, that said that they touch on something on succession as a direct appealable right to the court of appeal. Alafu initially haikuwa a matter yenye ilikuwa imekubaliwa to go directly to the court of appeal. It is a recent decision I'm also searching for the same so that tuijibu conclusively. But where the law haijasema there is a right to appeal yenye imekuwa guaranteed, you seek leave to appeal before a court. Sasa ndaipataje? Okay, I'm almost there. Where to appeal succession cases in Kenya. So there is a recent decision, na hii pia ni current affair. Let me read it for you. On 31st March 2026, Kenya's Supreme Court delivered a landmark judgment in Eliud Mwenda. Nimona Albert Pia has typed something on the chat box. You can also have a look at it. So the Kenyan Supreme Court delivered a landmark judgment in Eliud Mwenda Wandi versus Kevin Wanjohi Moshira, petition number 29 of 2024, settling a long-standing controversy over whether a litigant has an automatic right of appeal to the Court of Appeal from a High Court decision made in the exercise of its original jurisdiction in succession matters. So the case arose from a dispute over the estate of Mabu Mwenje, alias Peter Wandi Mwenje, who died intestate in 1998, leaving behind land in Kirinyaga County. The litigation traversed the Magistrate Court, the High Court, and the Court of Appeal, a journey spanning over 2 decades before finally reaching the Supreme Court. The Supreme Court decision authoritatively resolves the legal framework governing appeals in succession matters in Kenya. Which courts have jurisdiction to handle succession matters? We have the Magistrate Court, we have the Kadhi's Court, which handles succession matters involving Muslim estates, while the Magistrate Court pecuniary jurisdiction is limited to 20 million by a Chief Magistrate. Then we have the High Court, which has original and supervisory jurisdiction over all succession matters under Section 47 of the Law of Succession Act, Cap 160. And then we have the Court of Appeal and the Supreme Court, which serve as appellate courts in succession proceedings. So Section 47 of the Law of Succession Act is the foundational provision. It grants the High Court unlimited jurisdiction to entertain any application and determine any dispute under this Act, and to pronounce such decrees and make such orders therein as may be expedient. So significantly, the provision to Section 47 allows the High Court to be represented by resident magistrate appointed by the Chief Justice, enabling them to exercise High Court level jurisdiction in succession matters. Where does an appeal from a magistrate court in a succession matter lie? An appeal from a RM magistrate or a magistrate court in a succession matter lies to the High Court under Section 50 of the Law of Succession Act. So Section 51 of the Law of Succession Act provides that an appeal shall lie to the High Court in respect of any order or decree made by a resident magistrate in respect of any estate, and the decision of the High Court therein shall be final. What is the significance of the words shall be final in Section 51? The finality clause in Section 51 is of enormous practical significance. It means that where a succession cause originates in the magistrate court and is appealed to the High Court, the High Court's decision on that appeal cannot be further appealed to the Court of Appeal. So in the Wandi versus Macharia, the Supreme Court decision took note of this provision in its analysis. The court observed that Section 51 expressly prescribes both the right of appeal and the upper limit of that right. This illustrates Parliament's power to limit appellate access in succession matters, a power the Supreme Court acknowledged as legitimate, provided such limitation is expressly stated by statute. So the Wandi case itself originated in Kerugoya Senior Resident Magistrate Court, succession number 228 of 1998 under Section 51. So the matter then traveled to the High Court on appeal and later to a fresh High Court succession cause, which is where the original jurisdiction issue arose. Where does an appeal from the Kadhi's Court in a succession matter lie? An appeal from the Kadhi's Court lies first to the High Court and thereafter, in very limited circumstances, to the Court of Appeal. This is governed by Section 52 of the Law of Succession Act, which provides that an appeal shall lie to the High Court from a decision of a Kadhi's Court under this Act, and with the prior leave of the High Court to the Court of Appeal, but only on a question of Muslim law. So this provision creates a two-tier appellate pathway for the Kadhi's Court succession decisions, but it imposes two conditions on a further appeal to the Court of Appeal. One, prior leave of the High Court must be obtained, and 2, the appeal must be limited to a point of Muslim law. Then the question is posed before you. Why is leave required before an appeal from a Qadhi's court matter can go to the Court of Appeal? The requirement for leave reflects Parliament's deliberate policy choice to restrict the scope of appeals in Muslim succession matters. Since the Qadhi's court adjudicates matters under Muslim personal law or Sharia law, the Court of Appeal's appellant review is intentionally confined to questions of Islamic law, not factual disputes. Requiring leave also serves as a filtering mechanism to prevent frivolous appeals. Then, what is the procedural mechanism for filing an appeal from the Magistrate Court to the High Court in succession matters? The procedure is governed by the Civil Procedure Act and the Probate and Administration rules made under the Law of Succession Act. An appellant must 1. File a memorandum of appeal in the High Court within the prescribed 14 days of the date of the judgment or ruling, then specify the grounds of appeal, i.e. the findings of law or fact in the Magistrate Court that are challenged, then pay the requisite fees, serve the memorandum of appeal on the respondents, then preparation and service of the record of appeal, where the appellant is required to prepare and file a record of appeal containing all relevant documents, then hearing and determination. The High Court will then hear the appeal as a first appellate court having power to re-examine both facts and law, since Section 51 makes the High Court's decision to be final. In this scenario, no further appeal lies to the Court of Appeal. Where does an appeal from the High Court exercising its original jurisdiction in a succession matter lie? Now, this is where the Supreme Court expressed its reasoning. This was the central question resolved by the Supreme Court Wandi versus Mushira decision. An appeal from the High Court exercising its original jurisdiction in a succession matter lies to the Court of Appeal. So the constitutional foundation is Article 164(3) of the Constitution of Kenya, which provides that the Court of Appeal has jurisdiction to hear appeals from A, the High Court, and B, any other court or tribunal as prescribed by an Act of Parliament. So the Supreme Court confirmed that appeals from the High Court to the Court of Appeal in succession matters lie as of right, meaning without the need to first obtain leave of any court pursuant to the Article 164(3) of the Constitution. So, does a litigant need leave to appeal a High Court succession judgment where the same is arising from original jurisdiction to the Court of Appeal? And the answer is no. The Supreme Court held that there is no legal basis for imposing a leave requirement for appeals from High Court decisions given in exercise of original succession jurisdiction. The supposed leave requirement was traced to judicial practice and conflicting Court of Appeal decisions, not to the Constitution or statute. How did the court analyze the leave requirement? Okay, so the court surveyed statutory provisions where leave is expressly required. E.g., we have Section 39(3)(b) of the Arbitration Act, we have Section 75 of the Civil Procedure Act, we have Order 43 of the Civil Procedure Rules, and we have Section 52 of the Law of Succession Act. So, this is where the court observed that when Parliament intends to require leave, it does so expressly and unambiguously. So, it also noted that neither the Law of Succession Act nor the Probate and Administration rules contain any express leave requirement for appeals from the High Court's original succession jurisdiction. And then it went further to note that the requirement amounts to discrimination and offends the constitutional guarantee of access to justice. What is the practical implication of the Supreme Court's decision for litigants? The decision has wide-ranging practical implications in that in all litigations whose succession cause originate in the High Court in its original jurisdiction have an automatic right to appeal an adverse High Court decision to the Court of Appeal without first seeking leave from the High Court or the Court of Appeal. 2. Any previous Court of Appeal decision that struck out a succession appeal for lack of leave where the matter originated in the High Court may potentially be revisited. In the specific case of Wandi versus Mushira, the Supreme Court set aside the Court of Appeal's February 2021 judgment, reinstated the struck out appeal, and ordered it to be heard afresh on its merits before a differently constituted bench of the Court of Appeal on a priority basis. So, Peter, this was also in furtherance to your question on the difference between an appeal and a review, and we have seen at times the law can restrict to situations where an appeal can fall as of right, and where situations where an appeal cannot fall until you seek leave of the court, and when it comes to review, we have explained the thresholds to be met for both. So I believe up to that point, we have answered the question directly. So
Thank you.
thanks. How should courts apply conflict between domestic and international law? How should courts apply conflicts between domestic and international courts? Anyone who can attempt? Anyone who can attempt? So courts should resolve conflicts by applying the constitutional hierarchy. The Constitution is supreme. We have ratified treaties and general rules of international law that forms part of the Kenyan law but cannot override the Constitution. And where a statute conflicts with a treaty, the answer depends on one, whether Parliament has given the treaty domestic force, and two, whether the statute itself contains a treaty prevails clause. Otherwise, the letter in time statute commonly prevails domestically, while the state may still breach international obligations externally. So, to get the gist of our discussion, we read Article 2(1) of the Constitution of Kenya, 2010, supremacy of the Constitution. Any law inconsistent with the Constitution is void to the extent of the inconsistency. Then, if you read Article 2(5) to 6 of the Constitution of Kenya, incorporation of international law. The general rules of international law and treaties or conventions ratified by Kenya form part of the law of Kenya. Then, example of an express statutory treaty prevails rule was seen in the Section 6. Let us read Section 6 of the Public Procurement Act. What is it saying? So, Section 6 of the treaty of the PPAD Act states that subject to the Constitution, okay, the title is Conflict with International Agreements. So it says that subject to the Constitution, where any provision of this Act conflicts with any obligations of the Republic of Kenya arising from a treaty, agreement, or other convention ratified by Kenya and to which Kenya is a party, the terms of the treaty or agreement shall prevail. Where the Republic of Kenya is required under the terms of any treaty or convention to which she is a party to contribute from her resources in any form to any procurement activities within Kenya, either in part or wholly, jointly or separately, procurement through such contributions shall be, 1, in discrete activities where possible, and B, subject to the applicable provisions of this Act. So generally, this was just to point out that some statutes have directly stated the applicable laws where a treaty will prevail pursuant to our legislations made by the Parliament. So treaties are part of Kenyan law, but remain subordinate to the Constitution, and the Constitution controls any inconsistency. So courts will enforce treaty-derived obligations where domesticated or implemented and not inconsistent with the Constitution. So key takeaway is that if the conflict is treaty versus statute, check whether there is an express treaty prevails clause in the statute itself. If yes, apply it subject to the Constitution. So if no clause in the statute, the court typically reads the statute and treaty harmoniously where possible. If irreconcilable, domestic courts usually apply the clear statute, especially if later in time, while noting that the state's international responsibility. So the courts usually use international law as an interpretative aid. Where the domestic text is ambiguous, interpret it consistently with Kenya's international obligations, consistent with Article 256 of the Constitution of Kenya. So that is an answer to that question. The other one forms part of devolution. So from your end, you can't see, so I'll pull the slides upwards. So what is the benefit of devolution when it comes to division of revenue bill? What is the benefit of devolution? What is the benefit? So the benefits of devolution generally pursuant to the division of revenue principles. Devolution's fiscal architecture forces predictable, equitable, and accountable resourcing of counties. So this improves the local service delivery and reducing over centralization of resources. So that is it. You have equity and inclusivity, predictable funding, checks against re-centralization, and accountability and transparency. And lastly, we have improved intergovernmental relations discipline. So that was the answer to that. Article 168 of the Constitution of Kenya, maximum and minimum acreages for private land. Do we have a limitation? How is it to be applied? Article 168 of the Constitution of Kenya. Any attempt? Do we have any maximum or minimum acreages for private land in Kenya? Any attempt will be greatly appreciated. So up to that point, I take it to a motto that there is currently no fixed minimum or maximum acreage for private land set out in Article 68C of the Constitution. So the Constitution requires Parliament to legislate those limits, and the Land Act provides for the framework but does not itself specify acreages. So the operative constitutional idea is that Parliament must enact legislation on minimum and maximum land holding acreages. This is pursuant to Article 68C. Even the framer of this question got it wrong. It is not Article 168, it is Article 68 of the Constitution. So let us read Section 159 of the Land Act. Section 159 of the Land Act. Section 159 says that, subject to Article 40 of the Constitution, the minimum and maximum, the title is minimum and maximum land holding acreages. So subject to Article 40 of the Constitution, the minimum land holding acreage shall be subject to the provisions of Article 66(1) of the Constitution and the legislation envisaged therein. B. The maximum land holding acreage shall be subject to Article 61(a) and (c) of the Constitution, and the Cabinet Secretary shall publish guidelines on the penalties for non-compliance with the provisions of this section. So it does not set out numbers. If you read Section 161F of the Land Act, you will realize that it empowers the Cabinet Secretary by regulation to prescribe the minimum and maximum land holdings acreages for private land. So courts have flagged that there is a legislative gap in fully implementing Article 68(c)(1) of the Constitution and related land policy statutes, and have even directed the issue to the AG and Parliament for action. This was seen in the case of Wangai and 10 others versus the County Government of Laikipia 2022 decision. So that is the current situation. It has already been escalated directly to the AG and the Parliament, and maybe they are working on it. But this question was a practical question that was testing on the mastery of the Constitution as read together with the Land Act. Then before you we have question 90, questions before Honorable Harrison Omima Barasa. And if you read the question 90, aspects of conflict of jurisdiction between the High Court, ELC and LRC following the promulgation of the 2010 Constitution and how they have been reconciled by the Court of Appeal and the Supreme Court decisions. So post-2010 jurisdiction conflicts among the High Court, ELC and Employment and Labor Relations Court are resolved by a subject matter first rule. If the dominant issue is land or environment or employment or labor, the case belongs to the ELC or ELRC respectively, because these are courts of equal status, and the High Court is constitutionally barred, where we have constitutional drafting, cannot be used to pull the matter back to the High Court. So this was done through creation of specialized superior courts. So Parliament must establish courts of equal status to the High Court for A, employment, and B, ELC. This is pursuant to Article 162(2) of the Constitution. Then Oster of High Court jurisdiction. The High Court has no jurisdiction over matters reserved for the Article 162(2) courts. So ELC jurisdiction includes land use, title, tenure, boundaries, compulsory acquisition, land administration, and any other dispute relating to environment and land, and may also hear constitutional rights claims relating to environment. This is provided for under Section 13 of the ELC Court Act. So it can also hear constitutional rights relating to environment. On the other hand, ELRC jurisdiction is set out in the Employment and Labor Relations Court Act, commonly cited under Section 12 of the Act, covering employment or labor disputes and related constitutional questions arising from the employment relationship. Okay, so some judicial interpretation is where we have seen what we call the dominant issue control test or substance test. If the real dispute is land or title or occupation or use, you go to the ELC court. If employment relationship, appointment and termination of benefits, you go to the ELRC court. So the presence of constitutional allegation does not confer High Court jurisdiction. Sometimes we have what we call mixed petitions. The courts look for the predominant claim and then decline or transfer accordingly. So we have seen a decision known as Chunky Limited versus Patrick Ndune 2018, where the petition sought constitutional reliefs plus title-induced determinations. This was held to belong to the ELC court. Now we have answered that question accordingly.
Sorry, what's the name of that last case?
Sorry, the last case. The last case is known as Chunky Limited versus Patrick Ndune 2018. It was before the High Court because the High Court said that this petition is a mixed petition. It is bringing constitutional relief and it also has a title issue that is predominant before the court, and the court now decided to transfer the claim to the ELC because the ELC can have the jurisdiction to hear constitutional reliefs matters where the predominant issue is touching on land affairs. So thanks. Higher. Now the other question is a practical question. A person accused of a criminal offense is tried in the magistrate court and convicted. Appeals. Brian, your mic. Brian, you have not muted. Good. So, a person accused of a criminal offense. I'm a mute. So, a person accused of a criminal offense is tried in the magistrate court. He is convicted and appeals to the High Court, loses, then appeals to the Court of Appeal, and still loses again, then comes back to the High Court and files a petition for retrial. The petition is dismissed. He then comes back to the High Court and files an application for revision of sentence. Okay? The application for revision is dismissed. He then comes to the High Court with an application on the basis of decongestion in the interest of decongesting prisons. Which provision of the law is the application likely to be hinged on, or will it be a policy issue? Okay. So for context, we can break it down further so that you understand. A person has been accused and tried under the Magistrate Court Act and convicted. He appeals to the High Court, he loses, goes to the Court of Appeal, loses, then comes back to the High Court. These times, he files a petition for retrial. The petition is dismissed. He then comes back to the High Court and files an application for revision of sentence, and the application for revision is still dismissed. He then comes back to the High Court with an application on the basis of decongestion. in the interest of decongesting prisons. Which provision of the law is the application likely to be hinged on? It will almost certainly be treated as a policy or administrative decongestion request, not a fresh legal right to release. And given the conviction and sentence have been affirmed up to the Court of Appeal, the High Court will generally be functus officio and lack jurisdiction to reduce the sentence merely to decongest prisons. The proper legal route after exhaustion is typically the power of mercy process. So the High Court revision jurisdiction exists to correct illegality, incorrectness, impropriety, or illegality in subordinate court proceedings. It is not a general equitable power to reduce a lawful sentence for administrative reasons. This is pursuant to section 362 all the way to 364 of the Criminal Procedure Code. So decongestion as a court tool has been operationalized mainly through the following ways. We have revision in Brian Bado, your mic is still not muted. You have unmuted, Brian. So decongestion can be operationalized mainly through a revision of short sentences within the Criminal Procedure Code limits, and we also have community service orders as an alternative to imprisonment in eligible cases, often where the term is not more than 3 years. This is pursuant to section 3(1) of the Community Service Orders Act. So after final appeals, the Constitution provides clemency as the institutional mechanism for mercy or early release on public interest or rehabilitation grounds. This is pursuant to Article 133 of the Constitution of Kenya. So in this situation, the High Court could not have interfered with the same, and the only remedy existing for this person is under the Presidential Mercy Petition to the Power of Mercy Advisory Committee, where they will give a recommendation, then the President will make his own decision. That is the answer to that question number 91. What is an anticipatory bail? What provisions of law provide for it, and on what conditions will you grant the same? And lastly, you are a student at the Kenya School of Law. Do you know the draft that you will use when you are seeking the anticipatory bail? This one, people can attempt. It is an easy one. What document will you also use to seek the anticipatory bail? Do we have any provision in law providing for anticipatory bail in Kenya? And what conditions must you satisfy for you to be granted? Is it the Constitution that provides for the same? Do you know the application? So anticipatory bail or anticipatory bond is a constitutional protection order restraining unlawful or arbitrary arrest or detention where a person shows a real and imminent threat to liberty or other rights. It is not a statutory pre-arrest bail as of right, and it must not be used to block lawful investigations or charging. So we have various provisions of the law. If you look at the Constitution, this is the source of jurisdiction and remedy, where the High Court's Bill of Rights enforcement power and remedial jurisdiction, including conservatory or protective orders, is the anchor commonly invoked for anticipatory bail. This is pursuant to Article 22 and 23 of the Constitution of Kenya. Okay, so we have ordinary bail provision, post-arrest. Bail under the Criminal Procedure Code presupposes arrest and detention or appearance in court. It is not the direct source of anticipatory bail, but it is often cited for context. This is pursuant to Section 123 of the Criminal Procedure Code. So various courts have tried to interpret anticipatory bails. So this is granted where threat is real and imminent and rights risk are shown in the application. Then courts can impose reporting or cooperation conditions when granting this bail. Then the other test that has emanated is where we have purpose is for protection from abuse or harassment or arbitrary arrest, not immunity from investigations or prosecution. So courts often orders cooperation and provides that the order lapses on plea taking. So that was seen in Twitter versus Ethics and Anti-Corruption Commission 2023 decision. So where the applicant shows no credible threat, mere apprehension, or is being sought for legitimate investigation of a serious offense, the court will refuse. This was done in Mool versus Commissioner of Police 2022 decision. So key takeaway that you will require before granting this application is when you have credible evidence of imminent arrest and detention. Then you have a prima facie showing of likely rights violation. Then non-interference with investigations. Order must preserve the police mandate. Then we have proportionate terms, where we have reasonable bond and cash bail. Reporting travel limits will also be imposed, and automatic lapse clause. Remember, anticipatory bail will lapse upon arraignment or plea taking, where the trial court sets ordinary bail terms. This was seen in the Twitter case decision. You are as Kenya School of Law students, how will you draft this application on behalf of your client for you to be granted the same? We will approach court in the High Court of Kenya. So we start with the Republic of Kenya. In the High Court of Kenya, state the jurisdiction of the court, High Court, Human Rights Division or Crime Division, state the case number, write in the matter of Articles 22 and 23 of the Constitution, because you have seen that is the ground provisions, and in the matter of threatened violation of fundamental rights and freedom between I as the applicant versus who? The Inspector General of National Police Service being the first respondent, then you sue the DCI being the second respondent, then the Director of Public Prosecutions being the third respondent, then the Attorney General being the fourth respondent, because whenever you are suing any government entity, you must sue the Attorney General. You draft a notice of motion. The enabling provisions are under Article 22 and 23 of the Constitution, and all enabling provisions of the law, as we have seen under Article 123 indirectly, also provides for the same. Then take notice that the applicant shall move this honorable court for orders that 1. This application be certified urgent and heard ex parte in the first instance. 2. Pending hearing and determination, the applicant be determined to anticipatory bail and bond on terms the court deems fit. Then 3. The respondents be restrained from arresting or detaining the applicant in relation to the complaint or investigations concerning, you state the facts, then pending inter partes hearing or pending further orders. Then you must show the court that you are willing to cooperate. So the applicant is to present himself to the DCI at this date, this place and time for questioning, and thereafter as reasonably required. So that test you will have met a person to the court. Then lapse on charge in the event the applicant is charged and presented to the court for plea. These orders and will lapse, and the trial court shall set bail terms. Cost in the cause. So what are the grounds that you will use in support of this application? So you will state that there is a real and imminent threat of arrest and detention as shown by the facts that will be before you. Then the other ground is that the threatened arrest is likely to violate constitutional rights, including liberty and fair process. And then anticipatory bail is a recognized constitutional relief where rights are threatened. Then the applicant undertakes to cooperate and attend as required. The order will not impede investigations. So this is where the examiners will just look. They don't read your stories provided above. They just go to the grounds, because they know for you to meet the grounds, you must have known the threshold for you to be granted a certain relief. So we will be most likely targeting the grounds to be inserted in such applications when we will be analyzing the Civil Procedure Act 12 p.m. So those are the grounds that the examiner expects. What will you use to support your notice of motion? You will use a supporting affidavit. A supporting affidavit is a reiteration of what you said in the notice of a motion, but now you can annex documents in support of the same to show that it is not a frivolous application, and that in supporting affidavit you must also show that, or you must also show how you have met the grounds you have attached in your notice of motion. And once you have done that, you have correctly answered that question, both in the practical aspect and both in the theoretical aspect. Question 93. Limitations on anticipatory bail. any cases where the court has capped the time or given direction that it should not be unlimited? Do we have such situations? Do we have exceptions? Or do we have limitations on anticipatory bail? So the answer is yes. Kenyan courts routinely refuse open-ended anticipatory bail applications and instead cap it for a short period or direct that it automatically lapses on charging or arraignment of this person, with bail thereafter to be set by the trial court. So why it can't be unlimited? So anticipatory bail is a constitutional protective order that seeks to enforce the Bill of Rights and must be proportionate and must not usurp the police or ODPP's mandate to investigate and charge. An indefinite do not arrest order risks becoming immunity rather than rights protection. So we have seen decision known as Priscilla Nyakairu versus DPP 2021, where the court granted a personal anticipatory bond valid for 2 weeks and directed appearance before the DCI and set a mentioned date. Then we have seen the automatic lapse clause once a charging decision is made or upon arraignment. Some decisions have decided to stick to that. And we have also seen decision declining to extend or continue anticipatory bail once charges exist because trial court controls the bail. This was seen in George Warui Kiige versus AG 2018 decision. Extension was refused once charged and granted bail elsewhere. Anticipatory bail's purpose was spent. So we can say that exclusively you cannot seek an extension after you have been charged because the purpose of the anticipatory bail has been concluded. Section 210 of the Penal Code. What is infanticide? What sentence will the offense attract? What is the time frame within which the offense must occur for her to be said to have killed the infant because she was suffering from postpartum psychosis, and will the sentence resemble that of murder within 12 months? That is a question posed to you. What is infanticide? This is a crime where a mother has killed an infant because of maybe medical conditions on the state of her mind during postpartum psychosis, condition that generally affects some ladies after giving birth. So infanticide is provided under section 210 of the Penal Code is the killing of a child under 12 months by its mother, where at the time her mental balance was disturbed by mental conditions. So basically, I don't have a clear answer to this because unaona iko na aspect of medical situation, and maybe we read section 210 of the penal code in verbatim so that we directly deduce what the court can deduce of the CPC, so that we can see what the court is saying. Infanticide offense in Kenya. Is it really an offense, or you will be subjected to the medical test? So we have some key legal elements under section 210 of the Kenya Penal Code. This offense is treated and punished as manslaughter rather than murder. So age limit, the infant must be under the age of 12 months. So the perpetrator, the offender, must be the natural mother of the child. And mental state, the law recognizes that the mother's mental balance may be incapacitated, similar to postpartum depression, due to the physiological and physiological effects of giving birth or breastfeeding. Charge reduction, even if a woman is charged with murder, the court or magistrate can lawfully convict her of infanticide if the statutory criteria are met. So the maximum sentence, the offense is a felony that carries a maximum penalty of life imprisonment but we have seen judicial discretion. Kenyan courts consistently rule that the maximum penalties are not appropriate for first offenders in infanticide cases. Magistrates and high court judges typically request probation and psychiatric assessment before sentencing to ensure a balanced rehabilitative approach rather than a punitive one. This was the case of Beatrice Wambui Kariuki versus Republic, a 205 decision. So we have seen judges trying to be reasonable to various considerations like medical issues affecting the mental state of the mother. Yeah. So I believe that was an application question, because we ought to have known the key elements to consider before saying that you are to be punished in this crime. So we have seen it is manslaughter. Yeah. Now, what if she kills a child of a neighbor within 12 months? Does the postpartum psychosis also affect how this offense will be tried? This is also another application question. Do we have an exception? We have seen that one legal element is that the accused is a woman, must be the mother of the child. So if you're not the mother of the child, then that can be murder. That can be murder, because we have seen that even if the facts will otherwise amount to murder, she is guilty of infanticide and punished as if guilty of manslaughter. So if infanticide offense results to manslaughter, and that you have proved that you are the biological mother of the child, then a neighbor's child will be murder. Sawa. Is the mitigating factor postpartum psychosis discriminatory to men, since the same is not offered to men? Now this also targets gender discrimination angles. What will people say when it comes? Why is it not applicable to men? Do men have tendencies to show postpartum psychosis? Do men have the capacity? Do they breastfeed? Do they attach psychologically like the mother's brain? So the answer is no. Section 210 postmortem disturbance mitigation framework is very unlikely to be unconstitutional discrimination against men. It is a biologically grounded classification tied to childbirth and has a strong Article 27 justification. Infanticide is a gender or biologic specific partial excuse. It applies where a woman causes the death of her child under the age of 12 months and the balance of her mind was disturbed by giving birth or lactation, and she is punished as if guilty of manslaughter. So you cannot say that it is amounting to discrimination. Remember, differentiation is not discrimination, and we can justify that biological difference plus legitimate purpose, then we have we have a justifiable discrimination in place. So a father who goes on paternity leave and kills his child within 12 months will not have his offense tried the same way. So does this occasion discrimination towards men? We have directly answered that that will not be discrimination. That will be murder. Can there be malice aforethought when one kills their own child? Can there be malice aforethought when one kills their own child? We have looked at the elements of this offense, and we can say that generally we can infer yes, malice aforethought. Killing one's own child can be murder with malice aforethought. The relationship does not negate malice. So malice is determined by the accused intention and knowledge and surrounding circumstances, subject to any applicable partial excuses, e.g. infanticide under section 210 for a mother of a child under 12 months with postpartum disturbance. So remember the murder definition on section 203 of the Penal Code: unlawful killing with malice aforethought. What amounts to malice aforethought is described under section 206 of the Penal Code, that it is the intention to cause death or grievous harm knowledge that an act or omission will probably cause death or grievous harm, intention to commit a felony, and intent to facilitate flight or escape a felon. Then partial excuse between a mother and a child under 12 years plus the deserved murder may reduce what would otherwise be murder to infanticide, punishable as manslaughter pursuant to section 210. So malice is inferred from circumstances such as the weapon used, manner of attack, severity, targeting injuries, conduct before and after, and any threats that had been issued. So if infanticide is a narrow statutory carve-out, if its elements are not proved, then murder or manslaughter analysis applies normally. Okay, so if you are not in a position to prove the elements for infanticide, then you risk your client facing murder charges of the same. So allow me to log into something because I can see the time is 10:10. Let me switch off to brief. So basically we can be trying out question 99. Can a high court issue a structural interdict to give practical effect to the fact that abortion hinges on both the right to health and the right to life? Can such structural interdict be passed by the High Court? These were very technical questions. Very technical questions. So I'm logging into something so that we resume. So in the meantime, the Kenyan High Court can issue a structural interdict to make abortion rights workable in practice, so long as it stays within Article 26(4) limits and does not legalize abortion on demand. So the High Court has a broad remedial power to grant appropriate reliefs to enforce the Bill of Rights. That was the direct answer to that, because abortion is constitutionally permitted only within the Article 26(4) exceptions, where we have emergency treatment, danger to the life or health of the mother, in the opinion of a trained health professional, or as permitted by any other written law. This is pursuant to Article 26(4). So the right to the highest attainable standard of health, including reproductive health care, is protected by Article 43(1) of the Constitution of Kenya. So we have seen some decision known as FIDA versus AG 2019 decision that says that Article 26(4) exceptions, withdrawal of standards and guidelines was unlawful, and court issued a public law corrective order. So courts have also stated they have jurisdiction to issue structural interdicts under Article 23(3), including at interlocutory stages. So the answer is yes, they can issue structural interdicts. What are the powers given to the EACC by the Conflict of Interest Act? What are the powers given to the EACC pursuant to the Conflict of Interest Act? Can they arrest? Can they prosecute? Or their role is merely to investigate ethics concerns? So the Conflict of Interest Act, let me log in kidogo, the commercial. So the Conflict of Interest Act gives the EACC as the responsible commission for many public officers the right to investigation, enforcement and compliance management powers. Principally is to receive complaints, investigate, issue compliance measures and escalate for prosecution or disciplinary action where breaches occur. So if you read Section 7 of the Conflict of Interest Act, it is loading. If you read Section 7 of the Conflict of Interest Act, core powers of the Commission, EACC under the Act, include power to conduct investigations on its own initiative or on a public complaint being made. Okay. Then, what is the what EACC can actually do under the Act? They can intake or own motion action, where EACC can open matters suo motu or on a complaint pursuant to Section 7. We have also seen investigative conflict of interest conduct within its mandate population. This is pursuant to also Section 32 of the Act. Then route enforcement correctly depending on the officer, because responsible commission is officer's specific role, primarily where EACC is the responsible commission under Section 32. Then we have where another body is responsible, e.g. JSC for judges and magistrates under Section 32(7). Then we have the right to escalation, where criminality is disclosed. EACC investigation is typically escalated into the usual anti-corruption pipelines, recommendations to the DPP, investigative powers under ECECA, but the escalation comes from the broader anti-corruption statutory framework rather than conflict of interest alone. So we can safely say that they cannot prosecute; they only do investigations. So question 101, before you cannot be in a position to see. So I can try to sieve it out. Question 101, a group of girls applied to the High Court asking the government to provide sanitary towels and hygiene. We have directly pointed out when it comes to test on unfair discrimination. And then 102, the issue of body autonomy falls under, that is generally gender roles. We are trying to do questions that are inclining to the Kenya School of Law procedures. You are a High Court judge in a murder trial, and the only evidence availed by the prosecution is that the accused was the last person seen with the deceased. What will be your position in this matter? This calls for criminal litigation aspect. You are a judge in a murder trial, and the only evidence availed by the prosecution is that the accused was the last person seen with the deceased. What will be your position in this matter? So generally, I will acquit, or if at no case to answer stage, I will find no prima facie case, unless the last seen evidence is so tight that standing alone, it forms an unbroken circumstantial chain, excluding any other reasonable hypothesis. Mere proof that the accused was last seen with the deceased is usually insufficient by itself. So Section 203 and 206 of the Penal Code, murder requires proof beyond reasonable doubt that the accused with malice aforethought caused the death by an unlawful act or omission. On circumstantial evidence, any burden shift is limited to facts, especially within the accused's knowledge, and does not relieve the prosecution of proving the offense beyond reasonable doubt. Okay, so this is pursuant to Section 111 of the Evidence Act. There is a landmark decision on the last seen doctrine, as Albert has correctly pointed out in the chat box. The last seen can ground liability where it is conclusive and circumstantial chain is complete if the only evidence convictions are often unsafe. So I believe by Albert saying there is a landmark decision is referring to the Joey case, where the court stated that the last seen doctrine will also acting as a standalone test is not sufficient, but needs corroboration and a strong, tight circumstantial evidence to link the accused to the murder. The standard of proof is beyond reasonable doubt, and the burden of proof is on the prosecution. Are there exceptions to this rule? Do we have exceptions where the standard of proof beyond reasonable doubt that lies to the prosecution can also shift to the accused person? What are these situations? These are limited exceptions. So the prosecution always bears the onus of proving every element beyond reasonable doubt. But one, an evidential burden may shift to the accused on fact, especially within their knowledge. And two, some statutes create rebuttable presumption or reverse onus on specific elements and defenses. So generally, facts, especially within an accused's knowledge, this is seen under Section 111, one of the Evidence Act, where it places on the accused the burden of proving for the following circumstances bringing the case within an exception or exemption or qualification to the offense, and 2, any fact, especially within the accused knowledge, but it expressly preserves that the prosecution must still prove the legally necessary act or omissions and intent, and the accused is acquitted if reasonable doubt still remains. So this is one angle where the facts, especially within the accused knowledge, it is the onus for him to prove to counter the burden. So presumptions of fact where court may presume likely facts. So this is seen in section 119 of the Evidence Act. I'm opening the same, it is loading. Section 119 of the Evidence Act. It is loading from my end. So maybe I read in verbatim because the Kenya law portal is slow. It is very slow, but it will open. Presumption of fact, where court may presume likely facts. Then example of statutory reverse onus on an element, for instance, corruption. Section 58 of the Anti-Corruption and Economic Crimes Act, Cap 65. If the act is proved, it is presumed corruptly done unless the contrary is proved. Okay, so example of prosecution need not negative licensed authorities. So this is also seen in section 68 of the Narcotics, Drugs and Psychotropic Substances. So prosecution need not negative licenses and authorities. So it is the onus of the person who has been arrested. So Albert, you have duly pasted section 119 in the chat box, but my screen is it may freeze. Maybe you can read us through it so that we understand the basis of that exception. Albert, maybe you can read to us, because from my end, Makata, and I've seen you have pasted the same in the chat box. My screen may freeze. Brian, can you see the chat box? No, it's a link to the last seen doctrine. Okay, sawa. Imekataa kabisa Kenya Law Report. Evidence Act. Okay, let me see whether it can work this time. Good. So I'm going to section 119. Section 119. Section 119. 119. Presumption of likely facts. So the court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common cause of natural events, human conduct, and public and private businesses in their relation to the facts of the particular case. So that is where the court will take judicial notice or something of the sort. So that is it. You are an advocate representing a client, but the only evidence you have is a photocopy of a document because the original is with the adversary of your client. You need to have this secondary evidence produced in court. How will you go about it? This is civil litigation. What document will you draft? Okay. What document will you be required to draft? So you can produce the photocopy as secondary evidence by 1, laying a foundation that the original is in the adversed party's possession and power, and 2, serving a proper notice to produce. If they fail or refuse to produce, the court should admit the photocopy under the Evidence Act. So the key test that we were asking is whether you know section 67 of the Evidence Act, where primary evidence is the default. Documents must be produced by primary evidence except in specified cases. Then we have secondary evidence where original is with the adverse party. Secondary evidence is admissible where the original appears to be in the possession or power of the person against whom it is to be proved, and after the notice required by Section 69 of the Evidence Act, the person fails or refuses to produce. So notice to produce is anchored under Section 69 of the Evidence Act, and presumptions if a document is called for and not produced after notice, then the court will have to proceed with the photocopy before it. So that is it. What is the doctrine of recent possession and what are its ingredients? This is in criminal litigation. You can find an examiner asking various elements. You have been told to defend this accused person, state out the ingredients to the doctrine of recent possession. Then you are left surprised. So the doctrine of recent possession is a rebuttable inference that a person found in possession of property recently stolen is either the thief or a guilty receiver or handler, unless they give a reasonable explanation consistent with innocence. Okay? So the inference is grounded in the court's power to draw presumptions from proved facts and in possession concepts in theft or handling offenses. So in practice, it commonly supports convictions. So the presumption, so the ingredients are the following. So there must be that the property was stolen, so there is a theft or robbery or breaking offense occurred. The property is positively identified as the complainant's stolen property, not similar goods claims. 3. The accused was found in possession of the property. Then the possession was recent. Okay? Type of item, ease of disposal, and time gap is calculated to say that this was a recent possession. Then 5. The accused failed to give a reasonable explanation of the possession, or explanation is demonstratively false, at which point the inference of participation in the theft or robbery or handling may be drawn. So the test is 1. There is a theft, robbery allegation, so the property was stolen. The property has been positively identified. The accused has been found in possession. The possession was just recent, and the accused failed to give a reasonable explanation of how he came into custody of such goods. So the Court of Appeal, the Constitution of Kenya allows a person convicted of a criminal offense to petition the High Court for a retrial. What are the conditions that must be satisfied for the court to allow a retrial? What are the conditions that must be satisfied? Now you are a Kenya School of Law candidate. Being a Kenya School of Law candidate, examiner amesema, let me test this student. Hata anajua kudraft about a retrial application. Anajua kudraft. Do you know the test that we will have to mark person to your application? So that time examiner amesema, you are an adept reader of criminal litigation with 30 years experience of criminal litigation spanning around your waist. kindly give a proper advice and draft the necessary application to a person who wants to do a retrial petition. A retrial petition by a convicted person is only available under Article 56. This is where 1. Appellate avenues have been exhausted or time to appeal has lapsed. 2. New and compelling evidence has become available. Without both, the High Court must dismiss it as an attempted second appeal. So where is candidate pale? Kindly give the 2 threshold. Appellate avenues have been exhausted or time to appeal has lapsed, and new and compelling evidence has become available. Okay? So these are the tests. Constitutional thresholds provides for the 2 limbs. This is Article 56. It says that a person convicted of a criminal offense may petition the High Court for a new trial if the person's appeal, if any, has been dismissed by the highest court to which the person is entitled to appeal, or the person did not appeal within the time allowed, and B, new and compelling evidence has become available. So the both limbs are mandatory. Okay, so what counts as new? So evidence not available at trial and which, despite due diligence, could have not been obtained or produced, or evidence already in record or that could have been pursued on appeal is not new. Okay, what counts as compelling? So admissible, credible, high probative value and likely to affect the verdict, not just minor contradictions. So the petition is not for sentencing review, reconciliation or mercy. Such matters are not new and compelling evidence. So what document will you draft so that the examiner aone wewe you know what you are doing? In the Republic of Kenya, so you do a petition stroke a notice of motion for new trial under Article 56. Republic of Kenya in the High Court of Kenya, Constitutional Division, Constitutional and Human Rights Division, Constitutional Petition Number, in the matter of Article 56 of the Constitution of Kenya 2010, and in the matter of petition for a new trial on the basis of new and compelling evidence between I versus the DPP, first respondent, and to the Attorney General being the second respondent. Okay. A, there is a title known as petition. So the petitioner was convicted of this offense in this date arising from this matter and was sentenced to this number of years. The petitioner appealed to the High Court via this criminal appeal number and therefore to the Court of Appeal, and the appeal was dismissed on this date. I annex the judgment and rulings. Then there is new and compelling evidence that has become available after the conclusion of the appeal, namely describe those evidences. So 4, this evidence is new because you need to explain that it was unavailable and you had conducted due diligence. You had tried to obtain CCTV records from that premises, but hazikuwa. But now, due to AI, the person has enhanced his forensics capabilities, and I realized I was not at the scene of the crime. The petitioner therefore satisfies Article 50, 60, A and B being mandatory and is therefore entitled to a new trial. What are the prayers that you will be seeking? A declaration that the petitioner has satisfied the threshold under Article 56, and 2, an order that the petitioner be granted a new trial in appropriate trial court before a different judicial officer, and if needed, an order directing a government chemist or DCI or hospital to produce or avail the records for purposes of the retrial, and any further orders as the court may deem fit. As we said, attach the petition together with a supporting affidavit and reiterate the grounds that you want to rely upon. Okay, so that is it. Would the advance in DNA identification be the basis to reopen a case? We have decided to go with retrial, and we have said that DNA identification can lead to satisfying one element on we may realize there is a new evidence, alafu sasa hauna the second limb and they must be provable. Haujaenda Court of Appeal happy to prove that umemit, so on its own it will fail. Is public policy sufficient to justify setting aside an arbitral award? Okay, is public policy sufficient? This is civil litigation. Civil litigation combined with constitutional imperatives. You can see the lecturer is dealing with commercial litigation and a project Limited Liability Partnerships Act. So we said that the acts will be discussed next week, because I'm analyzing Companies Act, Limited Liability Partnerships Act, and the General Partnerships Act, so that we see various elements and questions that can arise from the same. So, is public policy sufficient to justify the setting aside of an arbitral award? So yes, but only in the narrow statutory sense. Public policy is an express ground to set aside an arbitral award, yet it is applied restrictively courts will not set aside an award merely because it offends a judge's sense of fairness or because the tribunal may have erred on the merits. So the High Court may set aside an award if the award is in conflict with the public policy in Kenya. This is read directly from Section 35(2)(b) of the Arbitration Act. Kenya law inanifail. Iko slow sana leo, iko slow. So Section 35(2)(b) of the Arbitration Act imesema directly that the High Court may set aside an award if the award is in conflict with the public policy of Kenya. Same concept is at the enforcement stage, where we have recognition or enforcement may be refused if contrary to public policy. This is also reiterated in Section 37(1)(b) of the Arbitration Act. So public policy is a closed, exceptional gateway. It includes awards inconsistent with the Constitution, laws of Kenya, national interest, or justice and morality, but must be specifically demonstrated. That was seen in the case of Gashuhi versus Evangelical Mission for Africa 2023 decision. So courts have warned that public policy is not a merit review tool. It cannot be based on a judge's personal sense of justice or concerns. So Court of Appeal has reversed High Court decisions that overstretched public policy to reopen contractual or procurement merits without a true public policy breach. So kama uko keen, the panels wanajuanga various exceptions, and these exceptions are difficult. Ukikimbilia pale kama hujasoma hizi vitu, automatically then you're going to fail, because a person can easily say that public policy cannot influence setting aside of arbitral award, but you have seen directly from Section 32 of the Arbitration Act that you can use public policy to set aside. So what is the basic structure doctrine and its application in Kenya? This is also a very potential question before the panel pale Kenya School of Law. They see whether unajua what was happening in the BBI case. What is the basic structure doctrine, and is it applicable in Kenya? Is it applicable in Kenya? So the basic structure doctrine is the idea that a constitution has core features that cannot be amended, or can only be amended through a higher constituent power or process. Even if the formal amendment procedure is followed, even if the formal amendment procedure is followed. So in Kenya, it is applicable at least at High Court level, where we had the BBI litigation, but its binding status is unsettled because the Court of Appeal overturned key parts of that reasoning, and the Supreme Court did not conclusively adopt the doctrine. So as the position stands in Kenya, currently we can say that the basic structure doctrine is not applicable in Kenya, but the High Court, the reason nasema hivi is because the panel can also decide to see whether you read through the decisions keenly. So the High Court ilisema that at the High Court level, the Nini was applicable, but the Court of Appeal overturned key parts of that reasoning, and the Supreme Court did not conclusively adopt the doctrine. So what we are left with is to follow the Supreme Court decision, and we say that the basic structure doctrine is not applicable. Kama mtu ameinua mkono, you can just unmute so that
What did the Supreme Court in the BBI case say about it?
I remember that the same is not applicable. It directly stated that it applicable. Let me search sahi Supreme Court summary for the basic. I rely on media sources as compared to reading the whole decision. So the Supreme Court's basic structure doctrine prevents the legislature after the verdict. In a narrow 7-6 decision, a 13-bench ruled that while the parliament does not have the power to amend the constitution, it cannot use that power to damage, abrogate, or alter the constitution's basic structure. Kama hapa constitution, Supreme Court ilikuwa ina hapa. Haya, where will I get this nini summary vizuri? Because you need to have a brief history of what was happening at each stage. You need to have a brief history. Tunapeleka kwa the Supreme Court publication. Supreme Court publication, copy basic structure. Mtu mwenye pia ataona atanisaidia. So this publication is appearing to be resourceful because it may outline various key landmark decisions. I'll share the same to the group. Mpaka inasema appeals raising issues of general public importance pursuant to section 163. So let me save it, alafu ndaituma pale group. Kuna National Bank of Kenya versus Anaj Warehousing. So basically imekupea the landmark decision. Kuna Nyutu Agrovet Limited. So pia tuwezi ingia orals kama tujui hizi decisions. Landmark from the Supreme Court. Jurisdiction to offer advisory opinion. Pia iko listed pale kwa hiyo publication. Appeals from tribunals formed under Article 168 of the Constitution. The doctrine of necessity imekuwa pia discussed. Ni kama nimepita hiyo, ni a very good summary kama ningepata hiyo ya nini, a basic structure, because kama tuwezi jibu the historical underpinnings, the historical litigation angle, then we risk failing just in case upatane na panel yenye wamekufa na wewe. So hiyo hakuna. The publication is very good for other landmark decisions, but haina hiyo basic structure. Who has a summary? Litigation history of basic structure. Okay. This summary. Okay. Good. Nimepata summary. Even the current status. Haya. So, the basic structure doctrine limits constitutional amendments, dictating that a constitutional core values cannot be altered by standard legislative processes. Its history in Kenya centers almost entirely around the 2020-2022 Building Bridges Initiative BBI litigation. So in High Court, May 2021, in the decision in David Ndii and others versus the AG, a five-judge bench ruled that the doctrine applies to Kenya. They declared that the foundational values of the 2010 Constitution form a basic structure that can only be dismantled by the people exercising their primary constituent power via a four-step process where we have civic education, public participation, and a constituent assembly, and finally a referendum. Then in August 2021, in the Court of Appeal, a 7-judge appellate bench upheld the High Court's ruling. They agreed that the doctrine was a valid legal mechanism in Kenya to protect the Constitution against attempts by the executive or parliament to replace or fundamentally alter its core identity. Then we went to the Supreme Court in March 2022. In a landmark consolidated ruling, the Supreme Court struck down the doctrine by a 6-1 majority. The judges ruled that the basic structure doctrine does not apply in Kenya. The court determined that the Constitution of Kenya 2010 already contains sufficient, clear and rigid built-in safeguards found in Chapter 16 to protect its core tenets. So the current status is that the Supreme Court ruling cemented that constitutional amendments must follow the exact procedural framework in Chapter 16 of the Constitution, where we have Article 255 all the way to 257, rather than relying on the unwritten judicial framework of the basic structure doctrine that is applicable in rather foreign states. So up to that point, we can say that sasa tuko na historical background of the BBI case and the current position as it stands today. So if it comes to during the orals, we will scoop the marks accordingly. So Jibet, have I answered the question?
Yes, thank you.
So thank you. So if you look at question 115, before you haiko visible, acha niweke laptop kwa moto. Question 115 before you scroll. Charge ina charge basi. So are you familiar with the Women for Scotland UK decision intersex? So I'm avoiding the intersex angle because we discussed here previously. Let us go to section 116 under question 116, yes. Under section 152 of the Criminal Procedure Code, who is a refractory witness? Surprisingly, hii question inarudiwa sana kwa trial advocacy examinations, because when it comes to trial advocacy examinations, wako na bias towards witnesses, wako na bias towards how you conduct your arguments before court, opening statements, closing statements, alafu wako na bias towards examination in chief, cross examination. So this is a trial advocacy question. So a refractory witness under section 152 of the CPC is a witness who, without sufficient excuse, 1, refuses to be sworn, or having been sworn, refuses to answer questions, or refuses or neglects to produce a required document or a thing, and 4, refuses to sign their deposition. So the court may adjourn up to 8 days and commit the person to prison unless they sooner comply. So the court may repeat the adjournment and committal cycles until compliance. This does not bar other punishment or proceedings, and the court may still proceed on other sufficient evidence. Okay, so that is basically what amounts to a refractory witnesses. Anakataa kukuwa sworn, na kama amekuwa sworn, he refuses to answer questions, or pia refuses to produce a document or a thing, and pia anakataa kusign their disposition. So that is who a refractory witness entails.
Highlight on the number of days of imprisonment.
The number of days to imprisonment tuliona ni how many days? Isn't it? Seven. Alafu unaona hiyo circle inashinda ikirudia, lakini pia tuliona pia hiyo the last test ya it does not bar other punishment. The court can still use its inherent jurisdiction to give a contempt of court a punishment or sanctions to you. Juu pia una go against court's directions. So if confronted with a refractory witness, what will you do as a judge? I'll first warn the witness and give them a chance to comply. If they persist without sufficient excuse, I will invoke section 152 of the Act, coercive procedure. I'll adjourn up to 8 days and commit the witness to prison for that period, repeating as necessary 7 days, while still proceeding with the case on other sufficient evidence if applicable. So pia mimi naona pia the court can commit you up to the 8 days yenye ime adjourn this matter. Si lazima ikuwe 7. Tuliona iko limited to 7. I don't think so. Maybe they can also decide to commit you for these 8 days. So the court may treat a witness as refractory where without sufficient excuse the witness refuses to be sworn, or after being sworn tumerudia, so it has stuck to our heads. So that's it. You have to warn and explain the consequences. Then kikataa, ingia na section 152 1D. Adjourn, commit to prison. Akikataa kabisa, invoke sasa ile the last inaitwa content of court proceedings. But kuna kitu kingine pia nimeona hapa, do not misuse section 152 as a judge. If the witness satisfies, if the witness testifies but turns or adverse or recants, treat as hostile and allow cross-examination. Do not remand. So we have seen maybe some judges misuse section 152 because there is even a decision to that effect inaitwa Dennis Mwiti versus Republic 2018, where a witness who merely recants a prior statement is not refractory. The correct course is to treat them as hostile, not to remand them under section 152. So kama na recant a prior statement that they had made, so don't treat it as refractory. Refractory ni mwenye anakataa hata kuwa sworn. So those are the key considerations when it comes to that provision. What is the doctrine of ripeness and justiciability? What is the doctrine of ripeness and justiciability? Is the matter ripe before court? Is the matter mutable? So ripeness means the dispute has matured into a real concrete controversy fit for adjudication. It is not speculative or contingent on future events. Justiciability means the issue is one the court is institutionally and legally permitted to decide. It's not a political question, not backed by separation of powers or privilege, and not moot and not premature. That is the key difference between the two. If you want to understand the historical underpinning, is where we have courts will strike out petitions that are premature or unripe because there is no crystallized controversy or the impugned process is ongoing. So we have seen a decision known as Sharma versus AG. This is a 2022 decision where the petition was struck out as being premature. Investigation and prosecution process still ongoing, and the court declined to intervene before the matter even matured. So that is it. Question 119. Which rights are not applicable to KDF? So that one is listed before you. We have privacy, Article 31. We have Article 36 on freedom of association. We have Article 37 on assembly and demonstration and picketing and petition. Then we have Article 41 on labor relations rights. Then we have Article 43 on economic and social rights. Then we have Article 49 on rights of arrested persons. Why don't they have a right of arrested persons? Nani anajua hiyo? Kwa nini KDF hawana rights of arrested persons? Maybe the punishment, maybe because pia of the nature of their duties. Which one is
I was only aware of the limitation of their freedom of association and assembly and striking, but here privacy and even rights of an accused person nimesikia leo.
So my answer inasema under Article 24(5) and the Kenya Defence Forces Act, KDF members do not lose Chapter 4 rights, but specific rights including Article 31, 36, 37, 43, 49 and 49 may be lawfully limited for military discipline and national security. They are therefore not inapplicable, they are restrictable on the terms set by the law. So KDF members enjoy a Bill of Rights protection unless limited. This is pursuant to Section 42 of the Kenya Defence Forces Act. Then we have some limitations kama Article 31 on privacy. It is limited under Section 48 of the KDF Act. So my Kenya law report iko slow, but KDF Act yenyewe imesema that we can limit your privacy rights if you join KDF. We have freedom of association. This is also provided under Section 50 on the KDF Act, specifically ban on joining prescribed associations or professional associations. Okay, then we have Article 37, assembly and demonstration and picketing and petition. This is directly limited also in Section 51 of the KDF Act to the extent necessary to maintain military discipline. Then Section 41 on labor relations. you cannot join a trade union or a strike. This is under section 52 of the KDF Act. Then article 43 on economic and social rights is still limited under section 53 of the KDF Act to the extent necessary for military training, operations, and follow internal regulations. Then rights of arrested persons it is limited directly pursuant to section 54 of the KDF Act, where you may be held without bail. Special custody rules and internal review requirements can apply. So that is where your rights. So examiner akikuletea pale mtu alikuwa KDF person akashika ukimbia pale kusema right to bail nini watu watashtuka. The examiner will just write sin. Tumeona. So that is it. So I believe now tumeona that these limitations are actually grounded under section 54 of the KDF Act, all the way from tumeona inaanzia 48 all the way to 54. So utacheza tu na hizo sections bora umeleta the point home. Can a person exit service in the KDF and sue for compensation of rights limited during his time of service? Can you exit? So sasa nimesikia watu wanapata pesa kwa employment matters. Can I sue for compensation of rights limited during his time of a service? Can you sue? So the answer is yes. After exiting KDF, a person can sue for compensation for unlawful rights violation suffered during service, but they generally cannot claim compensation because a right was lawfully limited under Article 24(5) of the KDF Act. So KDF members enjoy Chapter 4 rights unless limited under Article 24(5) and the KDF Act itself. So therefore, the legal question is always 1. Was the conduct within a lawful limitation framework, or B, did it exceed the lawful limitation or violate non-derogable rights? So damages can be awarded against KDF and state officers for rights violations even in a military context where we have unlawful denial of fair process notwithstanding Article 24(5) limitations. So we have a decision known as Erastus Hesbon Otieno versus Director of Military Prosecutions DPP 2019 decision. So KDF Act limitations generally constitutional, but petitioners' pre-trial rights were violated and the compensation was duly awarded. So we also see another decision known as Joseph Karubia Kinyua versus Commander of KDF and AG 2015 decision where unlawful detention and torture, because these are non-derogable rights, were limited, were exploited, and damages were awarded. So that is it, because where a petitioner is no longer in service and cannot access internal mechanisms, the High Court has declined to shut them out on exhaustion grounds because ametoka out of service, so he is within the jurisdiction of the High Court for remedies. Is the court martial a court of record? The answer is yes, because I remember this person aliulizwa hivi because alikuwa anakaa akisema that the challenge yenye ame-encounter in court martial stations is that kupata records when the High Court are requesting for these records from the court martial inakuanga ngumu. Hata judge wakauliza kwani hizi courts zinakuanga court of record? So the answer is yes, but ni kama kuna poor consolidation of these records, so that hata kama unataka kuseek judicial review ama in another forum inakuwa challenge. Hii ni yeye mwenyewe alifanya ulizwe hii swali and how he takes care of records zenye ana record, unaona, hiyo ndio ili arise hapo. So judicial enforcement of Article 50, has it been achieved? Question was tied to Mr. Masters because it was centered around how much was the, so you know, personal question. You see ingilia. Under what circumstances should the High Court depart from its own previous decisions or those of courts of equal jurisdiction? Very important. Civil procedure. In what instances, under what circumstances should the High Court depart from its own previous decision or those of courts of equal jurisdiction? pande ingine naona commercial transaction, the lecturer bado ana project the Companies Act, so directly inasema hii kitu huwezi penya kama hujachambua hizi nini. So under what circumstances, anyone who knows kama kuna illegality ama kuna evidence to show that maybe judgment was done in total disregard of the law applicable, so mimi hizo ndo elements. So what I had prepared is that the High Court should only depart from its own prior decisions or those of a court of equal status in narrow situations, principally where the earlier decisions is clearly wrong or per inferior, is inconsistent with binding higher court authority or statute, alafu is distinguishable on material facts or is no longer good law due to later legal developments. Otherwise, the proper course is to follow it or refer or empanel a larger bench where the issue is conflicting. So for you to answer this question vizuri, lazima useme about two tests. Kuna vertical stare decisis is mandatory, where the High Court is bound by the Court of Appeal and Supreme Court decisions. If a prior High Court decision conflicts with the higher court, the High Court must follow the higher court. This is a common law principle applied in Kenya. Then you have horizontal committee at High Court level, so not strictly binding precedent, but the High Court should follow decisions of courts of concurrent jurisdiction to avoid conflicting judgments and uncertainty, unless there is a good reason to depart from the same. So remember, the High Court judge cannot review or overturn another High Court judge. Grieved parties must appeal. Concurrent courts do not sit on appeal over each other. Another key takeaway is that where there are conflicting lines of authority on an important point, the proper judicial response is restraint, and where possible, referral for authoritative resolution, e.g. you request for a larger bench or you go to the High Court. So like we saw in the recent matters arising where the small claims do not have jurisdiction to hear RTA issues. What happened in this situation is that the High Court called for authoritative resolution, where the Chief Justice had to form a larger bench of 3 judges to hear conflicting decisions amongst High Court decisions, and now we can say that was complied with. We have seen directions on small claims court to transfer these matters to the magistrate courts on personal injury claims, but matters arising is whether material damage claims arising from the same accident, whether the same can go to the small claims or that decision merely meant for personal injury claims. So those are the arising matters that should be at your fingertips as we talk of the latest decision.
I think in the same box, when the Supreme Court departs from its previous decisions.
So angles, positions where the Supreme Court can depart.
Yeah, that's a possible question. When the Supreme Court can depart from its previous decisions.
Naona bado the element itakuwa where there is a legal change, there is a legal change kwa circumstances, but wacha nione chani Google hapa ndio nini kama itatoa media news. Nimepata decision inaitwa Rai and 3 others versus Rai and 5 others 2013. So you can just say, according to the Rai decision 2013, the Supreme Court will depart from its own precedent only for good cause, such as per incuriam or manifest error and similar compelling reasons. So it has been reaffirmed that there must be a demonstrated basis, whether there is a conflict, error, or public interest in factory to justify departure from earlier Supreme Court decision. So Supreme Court is not strictly bound by its earlier decisions, but departure is controlled and not routine. Review of departure is not a substitute for appeal. So hapa kuna landmark decisions that you must cite. Tuanze na Rai versus Rai decision. What was the ratio decidendi in this case? So the ratio decidendi was that the Supreme Court affirmed that while it has the power to depart from its previous decisions, such departure is only justified on compelling grounds, such as where a prior decision was given per incuriam or is manifestly wrong. The court found that its earlier decision in the Macharia case, which declared Section 14 of the Supreme Court Act unconstitutional for purporting to confer special jurisdiction on the Supreme Court beyond constitutional limits, was not per incuriam nor obiter dictum. The issue of Section 14's constitutionality was central to the jurisdictional question in Macharia and was properly determined. The court held that the Parliament cannot confer original jurisdiction on the Supreme Court beyond what is provided in the Constitution, and Section 14 was thus unconstitutional. The petitioner's arguments based on the right to a fair trial and access to justice could not override jurisdictional limits set by the Constitution. The court concluded that no exceptional or compelling grounds had been established to warrant departure from the Macharia precedent, and the application for review was thus disallowed. So that is one situation where an attempt was made to force the Supreme Court to depart from its earlier decision. Then another landmark decision was seen in Kenya. This is the decision of Fugicha versus Methodist Church in Kenya through its registered trustees and 3 others 2020. So in this, the Supreme Court held that its power to review its own decisions is strictly limited to the grounds established in the outer case and Section 21(4) of the Supreme Court Act, where we have fraud or deceit, nullity, mistaken belief of consent, or reliance on a repealed law or concealed statutory provision. So this now hapa sasa ina bring clarity that Section 21(4) of the Supreme Court Act ilikuwa imekuwa challenged na the Rai decision that the same was unconstitutional. So we have seen now another angle of that is being brought by Fugicha versus Methodist Church decision that says that Section 21(4) of the Supreme Court Act is the one that may lay out the various thresholds where the Supreme Court can depart from its own prior decision. Na ikasema kama kuna fraud or deceit, whether there is nullity, ama kuna mistaken belief of consent or reliance on a repealed law or concealed statutory provision. Kama ile decision ilikuwa ina trend ya Supreme Court judgment that had relied on an existing act, ilikuwa something to do with geospatial survey, kitu kama hiyo. That was also ground maybe. So the applicant failed to demonstrate that any of these conditions were met. The court emphasized that review is not a substitute for appeal and that the applicant was effectively seeking to appeal the earlier decision under the guise of review. So the court reiterated that important constitutional issues such as the right to wear hijab in schools must be properly instituted and canvassed through the judicial hierarchy before reaching the Supreme Court. The application for review was therefore dismissed as unmerited, and the applicant was directed to bear the respondent cost. The dissenting opinion argued for a broader value-driven interpretation of the Constitution, favoring substantive justice over procedural technicalities, but this view did not carry the majority. So this is also a question that has been asked in our project work. If you read the civil litigation question, whether substantive justice can override procedural technicalities, we can answer this using Fugicha versus Methodist Church in Kenya decision, Supreme Court decision. So I believe we can confidently now answer where we are being asked on situations where the Supreme Court can actually depart from its own prior decision. List 5 types of marriages. Hii sasa unapata the panel wenye wanataka tu upate tu the 9 piece bila kusumbuana na wao, alafu pale unaenda kuwa disappoint. You don't know the recognized 5 types of marriages. Kama unajua, you don't know the enabling provision to the same. So basically you can state that under the Marriage Act 2014, the 5 types of marriages are Christian marriage, we have civil marriage, we have customary marriage, we have Hindu marriage, and we have Islamic marriage. So that is it. The three C's, and Hindu and Islamic being religious marriages. That is it. A member of the Baha'i community says that the law has recognized 5 types of marriages and left his community out, hence the community is facing discrimination. What will be your position in this matter? Sasa huyu anakuja kusema there is discrimination because my community has been left out from the recognized 5 types of marriages. What will be your position in this matter? Is that discrimination? So the answer is a direct no. On the current law and authority, the Baha'i community is not left out in a way that makes the Marriage Act discriminatory. Baha'i marriages can be recognized or registered under the Act through a purposive reading, and the remedy, if any, is administrative inclusion in the registry frameworks, not invalidation of the marriage regimes. So the Marriage Act defines marriage systems commonly stated as Christian, civil, customary, Hindu, and Islamic, and then provides for registration and administration of marriages across faith communities through the registrar's framework. So constitutional anchors for the complaint will be equality or non-discrimination and freedom of religion. So do we have decisions to support the same? We have Mary Wanjuhi Muigai versus the AG, a decision that was passed in, when is the year to this decision? This was in, let me see, this was in 2015. Mary Wanjuhi Muigai versus the AG. The High Court has directly addressed the Baha'i complaint and held that Section 6 of the Marriage Act must be read to include marriages celebrated under all religious faiths duly recognized and registered in Kenya. So the omission of the word Baha'i is not a lawful basis to deny recognition or registration. So this was a live case that the panel was thinking that the candidate had duly read. So if you agree to recognize their marriage, what if other communities do the same? So tutasema they are also recognized pursuant to their faith-based registration recognition pursuant to that decision. Inaitwa Mary Wanjuhi Muigai versus the AG, Commission for the Implementation of the Constitution, a 2015 decision. So it directly answered that question. So woman to husband in the Nandi community dies and the wife seeks a grant which is opposed by the husband. Look at the case of Monica Katram decided by Justice Ojwang. So woman husband in the Nandi community dies and the wife seeks a grant which is opposed. Nini nasema? Wacha pia the framers of this question Nizasema pia walikuwa wana miss out on some elements when typing. So woman to husband in the Nandi community dies and the wife seeks a grant which is opposed by the husband. Okay. Okay, maybe we can rephrase it to seme wanauliza on Nandi woman to woman marriages. Okay, so that we can have now a balanced question. So that we will be pointing to Nandi woman to woman marriages, where the position is that the wife in a valid Nandi woman to woman marriage ranks as a surviving spouse or dependent and is entitled to petition for or be included in a grant, and an husband being a male cannot defeat that merely by denying the custom. He must disprove the customary marriage or show statutory disqualification. So preference in appointment of administrators is pursuant to Section 66 of the Law of Succession Act, where it is guided by statutory order of preference, surviving spouse first, then other beneficiaries, subject to the court's discretion. Then we have customary marriages, including woman to woman, are cognizable in succession if proved as a matter of fact or custom. So that is what the question was attesting. So the High Court has consistently held that woman to woman marriages under the Nandi and Kipsigis customary law are recognized for succession, and the wife is treated as a spouse or dependent for inheritance and for purposes of grants. We have that decision known as Ezekiel Kiptarus Mutai versus Esther Chep Kurui 2015 decision, where it recognized Kipsigis and Nandi woman-to-woman marriage applicant treated as wife or dependent, and grant issues were adjusted. So this can also come in an examination situation. Examiner aone kama you are a patriarchal person, whether ignore that woman-to-woman marriages are recognized marriage under the customary law, alafu wewe useme now the wife ati hayuko capable to take grants nini, so hapo utakuwa umeanguka from the word go. So that is it. What is the jurisdiction of court martial? It apply to KDF officers. How does Article 54 change the admissibility of illegally procured evidence? How does Article 54 change the admissibility of legally acquired evidence? How? So Article 54 replaces the old illegality doesn't matter approach with a constitutional exclusionary rule. Illegality or rights violating evidence is not automatically inadmissible, but it must be excluded if admitting it would 1. Render the trial unfair or be detrimental to the administration of justice. So basically we can say that the only situations where it can be excluded and where how Article 54 treats illegally procured evidence is where if the court admitting it will render the trial unfair or it will be detrimental to the administration of justice. So the courts have applied a two-limb test on this aspect. If you read the case of Republic versus Ali 2024, even where warrant issues were raised, the court treated admissibility as an Article 54 balancing exercise in context and not automatic exclusion. So the court applies a two-limb test on trial unfairness and detriment to the administration of justice and not an automatic bar. The other decision is known as Republic versus Philip Ondara Onyancha 2019, where confession excluded due to rights and process violations during recording. So where the manner of obtaining evidence compromises voluntariness and fairness, e.g. coerced confession, exclusion will follow. Then another situation we have Cyprian Nyakundi, the famous Cyprian Nyakundi versus DCI Victoria Commercial Bank 2021. Entrapment evidence can be excluded under Article 54 because it undermines fair trial and integrity. Evidence obtained through entrapment held inadmissible and the prosecution was restrained. If Kenya law allows, I want to read the ratio decidendi. So Cyprian Nyakundi and Emmanuel Nyamoya versus DCI and Inspector General of Police versus the DPP Director Commercial Bank 2021. The ratio decidendi was that the court found that the police, particularly CPL Odhiambo, were at the center of orchestrating the events that led to the petitioner's arrest, acting before any formal complaint was made and actively facilitating contact and negotiations between the parties. The evidence showed that the petitioners did not initiate any extortion attempt and only responded to persistent overtures from agents acting on police advice. The court held that absent the police intervention, the petitioners would not have committed the alleged offense. This conduct amounted to entrapment, rendering all evidence obtained thereby inadmissible under Article 54 of the Constitution. The prosecution based solely on such evidence was unsuitable and constituted an abuse of process. The court emphasized that entrapment is a complete defense and any trial based on such evidence violates the right to a fair trial, privacy, dignity, and due process. Consequently, the court granted the declaration sought, quashed the criminal proceeding, and prohibited further prosecution based on the impugned evidence. What is this entrapment in explanation word. Let us look at the general interpretation of entrapment ruling. Entrapment is when law enforcement or their agents induces or pressures or tricks a person into committing an offense they will not otherwise have committed, mainly to create evidence for arrest, prosecution, as opposed to merely giving an existing suspect an opportunity to offend. Okay, so this is where the offense is being facilitated by police officers or agents of the police officers. So if an examiner brings a situation where unaona there is an entrapment situation arising, you can plead entrapment as a defense on its own, as the courts have directly stated. So up to this point, I can say that we have finalized on this session, so that we take a break and now prepare for the 12 p.m. session on civil litigation drafting, where we have drafted order by order and the documents required per each stage. Then we will be resuming later when it comes to our orals tomorrow, half day. So basically I can say that we are learning a lot when it comes to these questions. We are learning a lot. We are learning various procedures that we never knew. We are learning various exceptions. Then we will have, because the questions are a total of 5-10 questions, but there are some questions which we are deliberately avoiding because they are not in our level, because they have centered towards the judiciary in a way. Then we are also eliminating questions that are repetitive or questions of general knowledge or directly meant to be addressed by a specific candidate. So that is it. Let me save the recording and upload pale YouTube. Then we will resume later. So thanks. Sawa.